You're not wrong. As pled, that paragraph is weak and in a few places flat out defective. Here's the straight talk, point by point, framed the way a judge would actually look at it. 1. Retaliation. For what exactly? Retaliation is not a vibes-based claim. It has elements. He has to plead protected activity, speech, petitioning, complaints, etc., adverse action, causal connection. This paragraph doesn't even allege the first element. No protected activity is identified. No complaint, no report, no speech, no lawsuit, no whistleblowing, nothing. Saying retaliatory harassment without stating what triggered it is conclusory and fails Rule 8 pleading standards. Courts dismiss this routinely. 2. Code enforcement, retaliation. What he describes as retaliation is a code compliance officer notifying property owners of violations, follow-up inspections to confirm compliance. That is literally the officer's job. Lawful enforcement activity does not become retaliation just because the violator is upset or films it. Absent selective enforcement or proof of improper motive tied to protected conduct, which he does not plead, this goes nowhere. 3. Standing problem. Frederickson isn't the property owner. This is a fatal flaw. The notices, enforcement actions, and emails were directed at property owners. Any alleged intimidation or burden fell on property owners. Any abusive process was exercised against property owners. Frederickson lacks standing to sue over enforcement actions taken against third parties. You don't get derivative civil rights claims because you were hanging around the property or causing some of the violations. Courts are brutal about this. Hannah 4. Self-recorded interjection isn't evidence of misconduct. By his own admission, Gray was speaking with property owners. Frederickson inserted himself into the interaction. He recorded himself doing so. That's not harassment. That's Frederickson voluntarily involving himself in an enforcement interaction where he had no legal role. A government official does not violate civil rights by refusing to treat a non-owner, non-tenant, non-party as a stakeholder. High 5. Surveillance incidents equals compliance follow-ups. Calling return inspections surveillance is spin, not law. Code enforcement officers are expected to revisit properties, verify correction of violations, document compliance. Absent allegations of stalking, trespass, or conduct outside statutory authority, none alleged, this is lawful administrative enforcement. Courts don't indulge dramatic relabeling of routine government activity. 6. Emails not addressed to him, it's not his claim. He cannot base claims on emails sent to other people, concerning other people's property, enforcing obligations owed by other people. No expectation of privacy, no deprivation of his rights, no injury in fact. This fails both standing and relevance. No abusive process. Abusive process requires an ulterior purpose, a willful act using legal process in an improper manner. Here, the process was code enforcement. It was directed at the proper parties. It was used for its intended purpose, compliance. That's the opposite of abusive process. Courts dismiss these claims early when plaintiffs confuse "I don't like this" with "this was unlawful." 8. No tenant rights, even if he was living there. This is another quiet killer for his claims. If he was occupying a garage, an office, a non-residential structure, then he has no residential tenancy, no habitability rights, no eviction protections, no standing to challenge residential code enforcement as an occupant. And if the use was illegal, enforcement against it is justified, not retaliatory. Bottom line, no sugarcoating. This paragraph is conclusory, lacks standing, fails to plead essential elements, and mischaracterizes lawful code enforcement as civil rights violations. It reads like grievance storytelling, not a viable Tay 1983 or retaliation claim. If challenged, it's highly vulnerable to dismissal, possibly with prejudice if he's already had chances to amend. If you want, I can rewrite this as a motion to dismiss section, draft a Rule 12b6 attack, or map which claims collapse purely on standing versus failure to state a claim. Just say the word. You're describing a reality he's either ignoring or genuinely doesn't grasp, and courts do not protect plaintiffs from their own discovery. Tell it like it is version. Discovery is where this case dies, even if it limps past a motion to dismiss. Even assuming a judge lets this survive pleading, which is generous, discovery is a meat grinder for his theory. property owners will be subpoenaed, emails will be authenticated, code enforcement records will be produced, videos will be played in context, timelines will be reconstructed. And here's the part Fredrickson doesn't seem to understand. Those witnesses do not belong to him. The property owners are the fulcrum, and they are not his proxies. His lawsuit is styled as him being the victim, but enforcement actions were directed at the property owners, notices were sent to the property owners, compliance obligations were imposed on the property owners. Any alleged pressure or intimidation was experienced by the property owners. Once they're on the stand, they will be asked, under oath, did Gray target you or Fredrickson? Were you enforcing code violations? Were you threatened or informed? Did Fredrickson contribute to or cause violations? Did Fredrickson insert himself into enforcement discussions? Did Fredrickson interfere with compliance efforts? If their testimony contradicts Fredrickson's narrative, and it almost certainly will, his case collapses from the inside. He cannot litigate other people's grievances. This is a core legal failure that keeps repeating in his filings. He cannot sue on behalf of property owners. He cannot appropriate their injuries. He cannot reframe third-party enforcement as a personal constitutional violation. Courts are explicit about this. Civil rights claims are personal, not transferable, not symbolic, and not improv theater. His pattern is to invent plaintiffs when standing is missing. You're absolutely right to point out the pattern. In this lawsuit, he implies enforcement against owners was enforcement against him. In the prior lawsuit, he tried to add fictional entities, including YouTube channels, out-of-state persons with no nexus, entities with no legal existence or capacity to sue. That's not a mistake. That's a standing workaround attempt. And courts don't tolerate it once they spot the pattern. Discovery exposes his conduct, not just the county's Ming. Another thing he's miscalculating. Once discovery opens, his actions become fair game, including whether he lived illegally on the property, whether he caused or exacerbated code violations, whether he interfered with inspections, whether he misrepresented his status, whether his videos omit context or provoke encounters. He thinks discovery validates him. In reality, it puts him under a microscope. Bottom line, blunt, he's trying to cast himself as the victim of actions that were lawfully taken, properly directed, experienced by other people. Courts don't let plaintiffs launder third-party enforcement into personal civil rights claims. And once real witnesses testify, especially the property owners, his narrative doesn't just weaken, it implodes. If you want, I can help you. Articulate this as a judicial narrative, how a judge would summarize the failure. Turn this into a pattern of abuse argument, or map the exact discovery questions that would dismantle his claims in minutes. Just say how hard you want to press.